All right, good morning, everyone. I'm Jason Hutt from Bracewell in the DC office. I'm joined today by two of my colleagues, Tim Wilkins in the Austin office and Kevin Voelkel, who works here with me in the DC office. Thank you for joining us again for Bracewell's Environmental Essentials webinar series. Typically, this is done on the first Tuesday of every month, but we've sort of come up with a March blitz of topics given all that's happening in this space, which I think has been heavily catalyzed by the energy transition and the new administration. Over the last couple of weeks, we've covered how the Biden executive orders are being used at the key environmental agencies. Last week, Jeff Homestead, Ann Navarro, and Daniel Pope talked about climate change as a policy driver in agency decision-making. Today, we're talking about environmental enforcement and adjusting to the new administration's approach. And then over the next couple of weeks, next week we'll have a webinar on the Department of Interior changes to expect in the Biden administration, which will cover onshore, offshore, Endangered Species Act, and the Migratory Bird Treaty Act. And then finally on March 30th, Matt Paulson, Kevin Ewing, and again Tim Wilkins will talk about ESG and SEC disclosure and the implications there. So for today, Tim and Kevin and I thought that we would talk a little bit about the external forces that are impacting the enforcement priorities at the federal level, a little bit about how there's been a sharpening of existing enforcement tools, some of the defensive considerations that you all might be thinking about as enforcement takes shape in the Biden administration, and then some proactive and preventative things that you can be thinking about as we move forward. So with that, I'm going to turn it over to Kevin to talk first about the external forces and the enforcement tools. So Kevin, take it away.
Thanks, Jason. As Jason mentioned, I'm just going to spend a few minutes talking about the administration's priorities that we expect will drive enforcement activity, as well as how the administration might use familiar tools to work towards those priorities. So first, I thought it would be helpful to level set and identify some of the external factors that influence environmental enforcement priorities. We know that enforcement decisions don't happen in a vacuum, and so there are a number of drivers. Some of these are structural, so to speak, and common across administrations, and some of which are issue-driven and guided by the policies of this administration. And so I think the first broad factor to acknowledge is the Biden administration's significant focus on climate issues. So President Biden has already taken a number of steps to signal the administration's focus on climate change, and that's included key appointments specific to climate issues and executive orders directed toward policy reform. But enforcement provides an additional avenue of action, and it's one that does not require the same level of process that rulemakings do. And so I'll mention more on this in a moment, but in the past, the Department of Justice and EPA have taken a broad view of remedies that are available in environmental settlements, and that's resulted in settlements in which the operator has agreed to environmental standards that are beyond what's strictly required to bring the operator into compliance. And that may not always have a tight relationship or nexus to the alleged harm. So from a climate perspective, this means that as part of settlements, emission reductions, for example, can be achieved beyond the level required by applicable regulations and permits. And so this makes emission reduction through enforcement relatively low-hanging fruit and something that we expect will be a product of the significant priority of climate. And then the next external factor that we expect will inform environmental enforcement priorities is the administration's focus on environmental justice. So environmental justice is an increasingly important topic. It's a movement to ensure that no group of people should bear a disproportionate share of the negative environmental consequences from government policies or enforcement. And there's another aspect that all groups should have a meaningful involvement in the government's environmental decision-making processes. And so President Biden's focused a good deal of attention on environmental justice issues during his campaign, and he's continued to highlight those issues in the start of his term. We've seen an executive order 14008, which concerned climate issues, including environmental justice issues specifically. And I think particularly relevant to this discussion, the order directs EPA to strengthen enforcement of environmental violations that would have a disproportionate impact on underserved communities. And that's through the Office of Enforcement and Compliance Assurance, or OECA. And it also directs EPA to create a community notification monitoring program, and that would collect data on emissions and then make that data available to surrounding communities.
Maybe it'd be helpful to talk about the role of data too, because we saw as EPA had limited resources, even in the prior administration, that desktop enforcement and data mining was really a trend. I know Tim handled a number of cases on the waste side where they were just doing that through desktop information. So what do you see as the role of this data that's going to be available to surrounding communities and enforcement?
Sure. Yeah, I think information gathering, and that's whether through community monitoring programs that are specifically referenced in the EO, or through information requests, 114 requests, or informal information requests. I think they're all important tools for the government, but what we've seen is that the government can also use this in a targeted manner to basically identify an enforcement basis for sources of emissions that it suspects will provide emission reducing opportunities. And I think this kind of is going to, this will kind of build on what I mentioned a moment ago and what I'll describe in a little bit more detail in a minute or two, but I think it really ties in because once the government has sort of the basis to enforce, it has the opportunity to negotiate for injunctive relief as part of a consent decree. And I think the injunctive relief can be a really powerful tool in achieving emission reductions on sort of a facility by facility basis. So I think the information gathering really is an amplifier of the tools available to the government. And so I guess the last thing I would mention about just the EJ executive order, the Environmental Justice Executive Order, is that it also actually suggests for DOJ to consider renaming what is now the Environment and Natural Resource Division to the Environmental Justice and Natural Resources Division. So it's just a clear connection being drawn here between environmental justice and enforcement activities. And Jason mentioned this in the beginning, but over the past month or so, Bracewell has hosted webinars on both environmental justice and climate issues, and that covers more than just the enforcement context. So I think those are can be watched on I believe on the Bracewell website. Okay, so just taking a step back, both of the issues of climate and environmental justice are going to be these policy-based drivers, but then we also have sort of the issues, in addition to the issue specific, we have the structural drivers, and that's things like personnel and budget. And with respect to personnel, the EPA administrator is clearly step one in framing the agency's high-level approach. But then there's also the important roles of the Assistant Administrator for OECA, the Assistant Attorney General for the Environment and Natural Resources Division. And this past Thursday, so I guess that's the 11th, Michael Reagan was sworn in as EPA Administrator. And he most recently served as the Secretary for the North Carolina DEQ. I think that even though it has not been filled yet, the Office of Enforcement and Compliance Assurance, the assistant administrator role there is very important because OECA sets EPA's enforcement goals and EPA's national compliance initiatives, which I'll turn to in a moment. And again, that's currently not filled, but it is currently the acting assistant administrator is Larry Starfield, who's a senior career official, has been the principal deputy at OECA. And then the last position of note is the Assistant Attorney General for the Environment and Natural Resources Division of DOJ. And yesterday, President Biden officially nominated Todd Kim to be the Assistant Attorney General for ENRD. And Mr. Kim currently is serving as the Deputy General Counsel for Litigation, Regulation, Enforcement at DOE. And I think prior to that, he worked in private practice and as Solicitor General for the District of Columbia. So even though it's high level, we're seeing that these structural elements like personnel are falling into place. And we're seeing that the first lever policy tools like executive orders are being used to set into motion the administration's environmental priorities. And so next, I just want to kind of briefly zero in on the more finely tuned levers that can set the tone for enforcement, as well as the specific tools available for the administration. One of these, I mentioned that OECA develops national compliance initiatives, or NCIs, and these are categories of activities that EPA identifies as representing serious non-compliance concerns. And so NCIs are a planning tool that allow the agency to focus enforcement and compliance resources on these priority areas. And I'll note that in the past, these categories were referred to as national enforcement initiatives. But during the Trump administration, OECA renamed these to emphasize the other tools available to correct noncompliance. And one difference in approach we saw under the Trump EPA was a movement to de-emphasize sector-based enforcement in favor of pollutant-based enforcement. And so, for example, that's targeting VOCs and HAPs, volatile organic compounds and hazardous air pollutants, instead of targeting specifically refineries or chemical manufacturing facilities or E&P activities. And I think that the NCIs are kind of a tool that can be really important in signaling the agency's more specific focus on enforcement. And then in addition to that, you have the common, the sort of familiar map of issuing memos to tackle issue-specific positions. And we saw that in the Trump administration, ENRD issued several enforcement-related memos relating to general enforcement principles, enforcement discretion, and related to kind of the scope of settlements. And we've seen, again, familiar in terms of a new administration, that President Biden has directed agencies to review those, and EPA has, ENRD has already issued a memo that's withdrawn 9 memos and other policy documents. And so I guess before I turn the mic back over to Jason, I just want to highlight the importance of approach with respect to the injunctive relief and settlements that I mentioned a moment ago. And I think as part of consent decrees that are entered into to settle judicial enforcement, DOJ and EPA have relied on a court's authority to provide equitable remedies to negotiate for injunctive relief. And that's requiring an operator to take certain action to redress harm. And often that's for a reduction in civil penalty, although it doesn't always have to be. And I think it's particularly important, again, to recognize that the Biden administration's approach to injunctive relief really has the potential to amplify the impact of targeted enforcement actions in a lot of meaningful ways. And so when we're talking about injunctive relief, we typically can fit the types of relief into 3 buckets, and that's compliance actions, mitigation measures, and supplemental environmental projects. And so conceptually, there's what distinguishes the buckets is how closely the activities are tied to the alleged noncompliance. And so a compliance action typically is to ensure that the operator's future activities are in compliance with law, so they're corrective in nature. Mitigation measures are typically actions to remedy, reduce, or offset the harm caused by the alleged violations, but those measures can be sort of in addition to what would be required to bring the facility into compliance. And then supplemental environmental projects, or SEPs, are actions that an operator agrees to take to achieve environmental benefits, but that go beyond what's legally required. And so even though SEPs go beyond what's legally required, we've seen that past EPA guidance has stated that there still should be a sufficient nexus between the violation and the proposed project. And so I just want to, although those lines are drawn conceptually, in practice, there are distinctions that do not always meaningfully limit the actions that the government negotiates for. And so when we're thinking about ways in that the government can achieve their policy goals through enforcement, whether sector-specific emissions or emission reductions more generally, without going through the notice and comment rulemaking, we think that injunctive relief can really provide a powerful tool. And SEPs in particular have received a lot of attention because they were further developed under the Obama administration and then discouraged and eventually prohibited under the Trump administration. But even without SEPs, the government has used mitigation to achieve actions that are not otherwise required by regulation or permit. And so I think, given the administration's focus on environmental justice and climate, the use of injunctive relief to achieve emission reductions, especially in excess of regulatory requirements, can be expected to continue. And I think we even increase as the administration looks forward to these priorities. And with that, I will turn it back to Jason to talk about strategic considerations in negotiating with DOJ. Jason.
Thanks, Kevin. So I think just it's important, even with a new administration, to sort of reflect on some of the classic tools or arguments that happen in the enforcement dialogue, to think about how those manifest themselves with this newer perspective. But certainly, you know, the first classic tool in the enforcement discussion is that the underlying violation does or does not exist, right? There's always a discussion over what's alleged versus what the regulated entity actually believes occurred. And sometimes, as Kevin highlighted, enforcement is driven around pollution reduction and not necessarily violations of the 40 CFR. So it's still important to frame the discussion oftentimes with the enforcement officials around what actually are the 40 CFR violations and which of those could be proved in a court of law if a settlement could not be reached. Many times, those 40 CFR violations are highly technical in nature, and so there is an opportunity to educate the lawyers and the technical people on the government side about whether those violations actually occurred or what information and data should be used to demonstrate that. In other cases, the alleged violation is a very subjective standard, like the general duty clause, where you're looking for the discretion of the enforcement folks to determine, you know, whether a violation did or did not occur. Then you have another classic place for discussion in the terms of a consent decree is the terms and conditions of that consent decree. The Department of Justice is put in sort of the unfortunate position that every time it negotiates an enforcement settlement agreement, that settlement agreement is published in the Federal Register. And so they default to saying that many of the provisions are boilerplate, because if they yield on a point in those boilerplate provisions in any one consent decree, the regulated community uses those relaxed requirements to try to negotiate in their own consent decree. You know, so some of those boilerplate provisions are a little more boilerplate than others. Certainly, there's greater attention on the transfer of ownership clauses and what sort of notices and consents need to be provided if you have a multi-facility consent decree. If you have a facility where you may sell a portion of the assets, you need to be looking forward and thinking about how those transfer provisions will be impacted during the implementation period of the consent decree. I think the whereas clauses are almost never boilerplate, but they are often an opportunity to tell the story behind the enforcement action, which becomes important when you think about the collateral consequences of the enforcement action. If you want to highlight cooperation, if you want to highlight whether the emissions or discharges associated with the facility were in violation of law, or whether there's an admission of those violations, because there could be collateral consequences associated with community litigation in the community. And then certainly things that are not as boilerplate are the relief provisions, right? Kevin talked about injunctive relief and mitigation to offset the environmental harm. Those are places where a greater degree of negotiation is an opportunity. Certainly the injunctive relief should be tailored to the alleged violation. Kevin talked about sort of the purchase that the Department of Justice and EPA have in demanding injunctive relief is that they're entitled to these equitable remedies. But there are classic tools that have been used there and that I would expect to be used in the enforcement, with the enforcement officials of the Biden administration, but independent third-party auditors talking over who's eligible to serve as an ITP. The scope of those audits oftentimes goes beyond simply assessing whether the facility is in compliance with the 40 CFR requirements and its permits. So looking at the scope of the audits. A harsher enforcement tool is court-appointed monitors. We've seen that in the cruise ship pollution cases, the mobile source defeat device cases. Those are usually more egregious circumstances, but it yields an expensive and difficult to control and very difficult to end implementation period. And so I think folks want to be wary of that and only enter into those sort of agreements if absolutely necessary. Other tools include the financial impact of the penalty or the injunctive relief and whether that's relationally fair to other settlements. So another advantage to the regulated community of being able to see all the other terms and conditions of other settlements is being able to compare yourself to those other settlements. There is an argument about whether a settling party has an inability to pay at the level that's demanded by the government. That is a difficult process that involves a lot of accounting review. And then there's a whole set of sort of classic tools in the criminal context, right? Because under many of our environmental statutes, there's a negligence standard that gives rise to misdemeanor liability. And that is very difficult to overcome where there's a significant harm involved. So if it's incident-driven enforcement, there's often a long dialogue with the government about whether there was underlying negligence. And there are a lot of collateral impacts to criminal cases, including whether or not you can have a combined settlement with the civil side. That's tricky to navigate because of information sharing limitations on the two sides of the Department of Justice, but it can be done. Other collateral impacts for any enforcement case, but particularly for criminal cases, includes your ESG policies. We're talking about that in a future webinar, but there's obviously an increasing emphasis on that, and an enforcement case will have to be informed by the ESG policy of the company. There's also increased emphasis on SEC disclosures and shareholder derivative litigation, and there's enforcement cases. There's the new guidance out on when environmental violations need to be disclosed from back in September. So be aware of your SEC reporting requirements. And last, I'll just mention that, and this is an often overlooked component of environmental enforcement, and that is the suspension and debarment risks. So many of you will think, well, I'm not a contractor with the federal government, and so that's not a significant risk to the company that I work with or for. And I think that can overlook sometimes the consequences of suspension and debarment, because if your customers are in contracts with the federal government, in particular leases or hold other land rights on Department of Interior lands, federal lands, or even Forest Service lands, Department of Agriculture, those customers may be precluded from entering into covered transactions with you that are greater than $25,000. So a classic example of that is an oil and gas upstream company leasing federal lands, or a renewable entity that generates wind or solar energy on federal lands. Their provisions of their lease require them to be in compliance with the CFR requirements related to suspension and debarment. And so if your entity is placed on the EPL's list, they may be precluded from entering into transactions with your company. So, and the suspension debarment dialogue with EPA Suspension Debarment Office or the Department of Interior's SDO is an entirely separate dialogue to determine whether or not the company is presently responsible. And the review of that agency the determination of that agency is very difficult to overturn because it is reviewed by an Article III court under an arbitrary and capricious standard. So something to keep an eye on as a collateral consequence of an enforcement case that I would expect continue to be used in the Biden administration. So I'm going to turn it over to Tim because we have a short period of time just to cover all these different topics, but to talk a little bit about how one can be proactive given the increased attention on environmental enforcement.
Yeah, thanks, Jason. Great overlay of what the sort of new environmental exposures are, and if you face enforcement, how to respond. I'm tasked with talking a little bit about what you can do in terms of readiness, in terms of prevention, proactive measures that you can use to minimize your enforcement risks, or at least minimize the consequences of enforcement should you face it. I've got 5 buckets I'd like to talk about very briefly. First, robust programs and management systems. Different organizations of different sizes, different geography, different size fleets, different complexity are going to have very different approaches to environmental management overall. But whoever you are, I think it is always worth considering gap spotting relative to established environmental management system standards like the ISO 14000 standard. Sitting down and thinking about how your programs run, how they have been effective or ineffective, questioning whether there are any blind spots either in substance or geography. Having a good, robust environmental management system is evidence of effort that the government respects. And if you've had any breakdowns in terms of environmental outcomes, whether you've had incidents, whether there's been a ball dropped on compliance, weigh how your standard operating procedures might be tweaked to have prevented that sort of continuous improvement cycle of looking for things that have gone wrong and tightening the procedures so that they don't go wrong in the future, really an exercise well worth undertaking. Second, inspection readiness, even exercises in the inspection readiness space. Have you been through agency inspections recently? Has everybody on the team that might be expected to face inspectors been through inspections recently? Think about what admonitions, legally speaking, you would want to give to the inspection response team, what they should and shouldn't be saying to the agency, and so forth. I would consider doing a drill, doing an exercise, doing a tabletop to see how people respond in an inspection sort of setting. I think about the roles, who's going to do what during an inspection conversation, and think through the likely scenarios, the questions and requests that the agency is likely to make, and how are you going to respond to that? Do you feel ready? I really think that engaging that exercise, especially if you've received a notice that an inspection is coming, but even if you have not, I think inspection readiness is appropriate. Third, compliance audits and audit disclosure. Compliance audits give you the ability to go look at how you're doing relative to your regulatory and permit obligations, to identify any gaps and to fix them, thereby staying ahead of the regulators. I think that is always worthwhile, but it's legally loaded, right? You're in the process of identifying non-compliance and possibly documenting that non-compliance in a way that could conceivably be used as evidence against you. If you're doing environmental auditing, compliance auditing, you have an opportunity to consider evidentiary privileges like the Texas Audit Privilege Act or like the attorney-client privilege. I would strongly consider that. If you don't know what you're going to find, consider undertaking privilege efforts so that you don't end up with evidence of non-compliance being generated and then used against you. But I would also consider audit disclosure. I think folks on this call are probably going to be familiar with this, but the Texas Audit Privilege Act, the EPA audit policy, policies in a number of states provide for you to go do an environmental compliance audit, to disclose what you find and to fix it, and to thereby obtain either immunity or leniency from penalties. There is a great opportunity to get ahead of the enforcement scenario and to get yourself into compliance, but also to extinguish penalty risks using these tools. Fourth bucket that I want to talk about is emergence from the pandemic. There is going to be evidence of rust on your systems, on your compliance effort. It's gonna happen. People are going to go back to work. People are going to be in the office, and they are going to trip over non-compliance issues that somehow got dropped when fewer eyes were on, when fewer boots were on the ground. And I think it's really important to think about maintaining eligibility for privilege and for immunity for that stuff that you trip over. You should be thinking about how can I take advantage of these audit tools so that when I discover problems that have happened, that I'm eligible for immunity or other benefits of the audit programs. Last concept, carefully consider the climate and justice relevant aspects of your facilities and operations. First of all, know your status. Are you a high emitting or low emitting facility from a greenhouse gas perspective? Are you going to be a target? Similarly, think about looking at your facilities through EJ Screen, the EPA tool to identify environmental justice communities. Are you located in an environmental justice community? Are you going to be targeted for inspections or enforcement because you are located in an area that involves disproportionate effects? I think those are things that you should know about the status. Consider prioritizing compliance efforts and compliance plus efforts at higher risk facilities. And I would also consider projects that you might undertake to improve your status relative to climate-related emissions and relative to EJ factors. You might consider whether to undertake some of those voluntarily as a way of demonstrating commitment and taking some of the enforcement heat off, but you also may want to consider projects that you might undertake as an element of some future enforcement settlement, knowing that the injunctive components that Kevin was talking about may be coming to bear. If you've thought about it up front, you might have better ideas for how to advance the ball in those respects than the stuff that the government's going to suggest to you, and it might be better for your company if you were to approach it that way. In any event, those are my 5 big buckets to think about on proactive and preventative measures, and we'll turn it back to Jason to wrap us up.
Tim, one question for you. I think people have a healthy skepticism about audit disclosure because the concept of finding your problems and sharing them with the government is one that they're wary of. And I know you have a lot of experience with how the government actually reacts to those disclosures, whether they honor those policies. And I think importantly, whether the new administration will approach that differently. Just curious about your experience in that space.
Well, let's start with the states. With Texas, I think the program is very robust. I think it is a program with which there's a lot of participation. And my experience has been that TCEQ honors the program as enacted by the legislature, as envisioned in TCEQ's guidance. Had good experiences with the Railroad Commission as well, by the way. But that's the state angle. Different states have different approaches to this. Most states do not have as frequent flyers as we do in Texas. And I think the agencies sometimes are less familiar with their own policies that are sometimes kind of dated now. And so you really want to think locally about whether an individual state is the right place to go. But in Texas, I would say absolutely. In terms of the EPA audit policy, we have moved as of about 5 years ago to the EDisclosure Portal, where stuff gets uploaded through EPA's CDX exchange. You just upload your disclosures that way. I think there are more limited benefits to the EPA approach, but I've still had very good results where there are federal lead programs, in particular, Tier 2, TRI, SPCC, issues like that where it's more of a federal lead and less of a state role. I've used it to good effect, had situations where inspectors had shown up or we received calls from regional offices and a disclosure was made already, and they'll just shut down an enforcement action they were considering based on that having already been disclosed through the portal. So I would encourage you to think through each issue carefully and determine whether it really makes sense to disclose. But I think all of these tools are good tools, but the EPA audit policy has maybe a more limited applicability and more limited benefit than, for example, the Texas program.
Terrific. Well, thanks everyone for joining us today. And as Kevin Voelkel mentioned, each of the webinars is available on our website, and you'll receive an email thanking you for attending, which will include a link to the slides, which will have some of the substantive content that we covered today, and obviously help everyone to check the box for CLE credit. So please if you have questions about that or anything that we covered today, feel free to reach out to any of the three of us. Our contact information is on the last slide. We look forward to seeing you on the future webinars here over the next couple of Tuesdays, and then at our May seminar, which will again be virtual. That's the semi-annual seminar that our environmental team puts on once in May and once in November of each year. So thanks again for joining, and good to be with you all. Thank you, Tim and Kevin. Bye-bye.